The gentleman yields.
Without yielding the floor.
You know, I know that the senator, my friend from Kentucky, agrees with me that the defense of our country and the protection of our civil liberties should be bipartisan and above politics. And I know that he agrees that we can and must protect our citizens without violating their civil liberties. And again, my good friend, I don't always agree with you on every issue, but when it comes to this nation's intelligence gathering and security, we agree more than we don't. Like him, I was deeply troubled by the revelation that our country was engaged in bulk collection. I think we all were surprised. And millions of private citizens' data was gathered unknowingly and unjustifiably. In 2013, Edward Snowden revealed to the American public that the NSA was engaging in the bulk data collection and sweeping up virtually every cell phone record of an enormous number of Americans, again for no reason and no cause. The U.S. spying program did this by systematically and indiscriminately collecting millions, I mean millions of American phone records by simply taking up every phone record that came in its net, even if it wasn't remotely related to the broad general search. These are not searches that were relevant to a particular threat or an individual group. It was just a huge database documenting what millions of law-abiding citizens were doing. That is not what this country was based on. And I think you've made that very clear, sir. And I know that you believe that this was wrong, as I do. And that is not just our opinion. National security experts, legal experts, the American public, and even several courts have said that the bulk collection of data is not only unconstitutional, but also unnecessary to our national security. And to my friend from Kentucky, he has confirmed that the President's Review Group has said the bulk data collection is not essential to preventing attacks, and that program has not made a difference in a single instance. The bill that the Senate will soon be considering, the USA Freedom Act of 2015, will ensure that we restore important privacy protections for Americans. The United States will always face security threats. I think we all know that, and for generations to come. That's just a reality. On that horrible day, September 11, 2001, we as a country were reminded of this fact and realized we must meet those threats with strong law enforcement and strong intelligence. However, we must also balance that necessity with our constitutional rights. The NSA bulk data collection program clearly did not strike that balance, and the District Court of D.C. and the Court of Appeals of the Second Circuit of the United States struck it down. The courts have made clear this program is not legal, and I understand Senator Paul and Senator Wyden's frustration with any suggestion that it be continued. I believe this bill, USA Freedom 2015, moves us in a positive direction. It ends the bulk data collection program and ensures that the collection of data is related to a relevant, particular terrorist investigation. At the same time, it still protects this country. The USA Freedom Act of 2015 replaces indiscriminate bulk collection and allows the government to collect call details of records on a daily basis if it can demonstrate to the FISA court a reasonable, articulate suspicion that its search term is associated with a foreign terrorist organization. The bill provides greater transparency about surveillance activities. It contains significant new government reporting requirements for FISA authorities to ensure its activities do not again break the law. It gives private companies increased options for reporting to the public information about the number of FISA orders and national security letters that they receive. The bill requires declassification of FISA court opinions containing significant legal interpretations. The bill requires the FISA court to designate a panel to appoint individuals to advise in particular cases involving new or difficult legal issues. It expands the opportunity for the appellate review of FISA court decisions. The bill strengthens the judicial review process for gag orders. It imposes new privacy protections for FISA pen registers and limits the use of unlawfully obtained information. And the bill also contains many provisions to protect our nation's security. It creates a new emergency authority to allow the government to obtain business records, including call detail records, without advance court authorization. if an emergency requires those records. It also adds a short-term emergency authority for continued transnational surveillance of foreign terrorists or spies who come into the United States before emergency authorization can be obtained from the Attorney General. It permits ongoing FISA surveillance of an agent of foreign power who temporarily leaves the United States. It clarifies that individuals can be subject to FISA surveillance if they are knowingly aiding, abetting, or conspiring with respect to the proliferation of WMD on behalf of a foreign power. And finally, the bill increases the statutory maximum penalty for material support of terrorism from 15 to 20 years. Now, I know the senator from Kentucky does not think it goes far enough in protecting our privacy rights, but perhaps my good friend Ken remind us again on what provisions that you would like to see changed or strengthened in the bill to satisfy your interest and maybe Senator Wyden's interest and other people. I would yield the floor back to the senator from Kentucky to hear basically his concerns of how we can have some protections, and do we have any rights whatsoever to gather information when it's proven. I've heard you say that you thought if we could prove it, there was a definite concern that we had, you can get FISA courts and basically move forward from there. I thought this bill moved us in a positive direction. The new bill we're considering, or about to consider, sir, if you could explain to me maybe your concerns about that or what we need to do.
Let me make sure I have the question correct. Your question is on the USA Freedom, my concerns on the USA Freedom?
USA Freedom 2015.
Yeah. I want to like it, and I want to because it ends bulk collection, and I'm all for ending bulk collection. So we all agree. The people for it agree with the problem. It's a question of whether it's a solution. It says that there have to be specific selector terms on U.S. persons. Part of my problem is that persons is still defined as corporations. My concern is that you could put the word Verizon in there and the government wouldn't be collecting the records, but you still could get all the records from Verizon. You see what I mean? Because that's one of my concerns in the way it's been written. And my other general concern is that would we still be having bulk collection therefore, but it wouldn't be all done by the government, but it'd still be bulk collection through the phone companies. And I don't like the liability protection because I think it makes it more likely than not that your privacy agreement won't be as respected if they cannot be sued for violating your privacy agreement. Those are a couple of concerns. I don't know if they're insurmountable, but those are a couple concerns.
I think we both agree. I think mostly everybody in this body agrees that the bulk collections were wrong. They were proven to be illegal and should not have been done and should be stopped. I think we're all in agreement to that. We still know that we face considerable threats from around the world on a daily basis, if not even greater than that. And we were looking for trying to find the balance, and I think that you are valuable in helping us find that balance. I really do. And that's what we're looking for. And I know that your colleague, Senator, and my colleague, Senator Lee from Utah, has made a gallant effort trying to find that balance and making sure that we didn't overstep. The private companies are collecting. They already have that information anyway. It's not just sweeping from NSA as they had been doing. And basically, I'm understanding by this bill, the 2015 USA Freedom Act, where basically we'd have to demonstrate to the FISA court reasonable, articulate suspicion that its search term is associated with a foreign terrorist organization. They can't even go into those records until that's shown. That's the way I understood it. I'm not sure if there's something I'm missing.
Yeah, I guess the question I have is that we had some of those restrictions now, but they seem to think that those restrictions don't apply to collect. You know what I mean? The people interpreting what we have now are interpreting 215 to mean we can collect all the American records in bulk. If there were a way that I was necessary to pass USA Freedom and it were that close, if people were willing to look at the bill and say, we would make a person an individual. See, the big thing for me is that a warrant should be individualized. And I'm worried that when you use the word person, if it can be replaced with the word Verizon, and we could still collect all the records, I would feel really disappointed if we thought we got rid of bulk collection And then a year or two from now, when they finally admit it, they'll admit, oh, we're still doing the same thing. We're doing Verizon. We're getting all of Verizon's record. We're just making them process it and we're paying them for it. That's my fear, is I want to make sure that doesn't happen.
I guess we're caught in that Citizens United decision, it sounds like.
In a different way. But I mean, we are talking about whether or not in the intelligence selector numbers, whether or not a person is a corporation and whether or not you can have a single warrant. See, I think if you want phone records from Verizon, it would say Verizon and we want the records of John Doe. It shouldn't just say we want all the records from Verizon. That to me is a general warrant. I'm still fearful that the USA Freedom Act may not limit that.
If the Freedom Act, as it goes away, okay, the way that they've been doing bulk collections, which we agree should be done away with, and we don't come to some agreement, are you concerned that we might be in more jeopardy by not having something in place to where we're able to get the necessary intelligence we need?
And I guess that's where I also probably differ. I think we are just as safe or safer with nothing, because the Constitution allows the searching of records, and I'm all for it, but I would do it through warrants. And here's the thing is data, metadata, you can do a hop or two with these less than constitutional warrants or whatever, but with a real warrant, you can go 100 hops into the data. So I really would chase the rabbit down the hole. I mean, I really would look very hard with suspicion, and I think warrants are generally easy to get. This is a point that I don't get about why we have to have warrants that have a lower constitutional standard, because I think that the FISA warrants are almost never turned down, but neither are criminal warrants. If you are a policeman standing in front of a house, you almost never get a no, you know? But if you're a policeman and you say, I want to search all my neighbors' houses, judge is going to say no. And that's a good thing, you know? So I think traditional warrants, I think people have somehow just convinced themselves we can't catch terrorists with traditional warrants, but I think you can go through a lot of data with traditional warrants too.
Basically, that if it sunsets, the bulk collection, the way the Patriot Act has been enforced before, sunsets and it goes away, which we agree. We were trying to replace that before the sunset. You believe the system that we have in place today, I mean the system we've had in place before the Patriot Act of 2001, gives us still the ability to keep the homeland safe using the court system, as you say, follow the rabbit down the hole, using the court system. Let me say because we know we have rapid fire coming at us from different directions and people trying to come into this country and do harm. The social media has blown up since even 2001, so we're much more vulnerable from that standpoint. And what I'm hearing say also, you're not really objectionable, and if you can find the right language in that freedom, if you thought that you could get to that protection of that individual without the interpretation of the entire broadness of the corporations.
Right. I think that also within the context of we have 6 or 7 amendments that we'd like to introduce. Can't guarantee that we can win any of them, but there's a chance maybe we could win another reform. So for example, one of the reforms that some people think may be as important as all of the bulk collection is the ability of the government to tell an internet provider that they have to create a backdoor to their product for the government to go through, and some of the backdoor stuff through 702. We think there are some other things that may well be as big as this. I also think that there is the ability of the government not only to use traditional warrants, they have some they're using under executive order as well as we still have, you know, a host of other types of warrants and subpoenas being used. But I would never be for this in a heartbeat if I thought it was going to make the country endangered. I think we'll be safer because of it, and so will our liberty.
The good point of the bill that we will be considering, which is the 2015 Freedom Act bill, it expands the opportunity for the appellate review of the FISA court decisions, which I think you've had a problem with too, because it's just been handed out uncontested, correct?
Say that again, please.
The appellate review, the bill that we will be considering is expanding the opportunity for the appellate review of FISA court decisions, which I think and I can understand, you're saying they can get a FISA order no matter what.
I'm not sure if I understand the question, but I do believe that the court case right now, the way it stands, if the USA Freedom had passed last year, I think there's a chance it might have made the court case moot because it would have said, oh, Congress has already acted, and Congress now has given an authority for a variation of this, and Congress already fixed the problem. So there's part of me that would like to see the appellate court case go up to the Supreme Court. It's been remanded to a lower court, so I don't know if it's ever getting there. But we ultimately have some questions in our country that won't be decided till we have a Supreme Court case. And one of those questions is, do papers have to be physical and in your house? What if they're digital and lodged somewhere else? Do you have any right of privacy, any Fourth Amendment protection at all for records that are held somewhere else? The current legal opinion doesn't really give any protection to third-party records. I think that needs to be fixed because I think technology has made it such that our records are no longer going to be real records that you can hold in your hand. I think almost all of our records are going to be virtual and held in space somewhere, and I think you have to still have a personal privacy protection in those.
So the bill that we have proposed before us, it's going to require declassification of FISA court opinions containing significant legal interpretation, which is positive thing.
There's a lot that I like in the bill. It's just a matter of whether or not I can be convinced that it doesn't allow bulk collection under another name. I'm still worried about that, but I'm open to it. And see, some of these things, this is a very important bill. I mean, we could have a week's discussion on this bill and amendments and a process. And the only reason we're getting a little bit of this is because I'm kind of forcing the issue. But I'd like to see the amendments voted on. And all the other stuff we're doing around here is important, but has no deadline. We could have done it next week, 2 weeks from now, all the stuff we're doing right now. So, but anyway, that's what I'm going to be asking for is the ability to present 5 or 6 amendments, vote on them, and then we'll see. And I'm more than willing to talk with the authors of the USA Freedom Act to see if there's a way. But it's going to have to involve maybe some give and take to figure it out.
Well, it sounds like we're not that far apart. I think that we're all going down the same path, trying to find a way to keep the homeland as secure as humanly possible, but protecting the rights of all Americans. And I appreciate that, and I hope that we do. These are important issues. And it's a dangerous world we live in. It's a threatened world that our children are being raised in, and we want to do everything we can to protect them. I know you do too. With that, I think we all come to an agreement that what was done before was wrong. So we all have come unanimously to that agreement. Finding the pathway forward is the one we're working on now. So I appreciate your in sincerity and intent to try to reach out and find that. And I hope that you can find that comfort level that we can move forward and still have a protected country. Thank you.
Well, I thank the senator from West Virginia, and I think that he's made some really good points. And I think a lot of us have come to the agreement that there's a problem with bulk collection. I don't think we're yet to everybody. I think we're to a significant number, though, that agree. The court agrees with us. And so I think we are getting closer.